Hello, I'm Don Maurice, and welcome to Short Sales, One Form of Action Rule, and Anti-Deficiency Protections, brought to you by the Consumer Financial Services blog. And it's a pleasure to be joined today by my colleagues at Maurice Wutscher, attorneys Eric Tsai and Patrick Kane. Eric is coming to us from San Francisco. Hello, Eric. How are you?
Hello, Don. Thanks for having me. It's a pleasure to be here. I'm very excited to be able to give this presentation and hopefully answer any questions that any of our attendees may have today.
Great. And also joining us from lovely San Diego, California is Patrick Kane. Hello, Patrick.
Hey Don, how you doing?
Great, thank you. Both Eric and Patrick are litigators experienced with the issues we are discussing here today. A few things about your questions. If you have questions, use your chat panel that's to the right of your screen. Just type them in there and fire away. We're going to do our best to answer all of your questions during the presentation. But it may be possible we'll run out of time and we can't get to them. Don't worry. We're going to answer all the questions that we get, even if we have to do it after the webinar. Now, one final bit of housekeeping. We are attorneys, so we have to tell you that the information in this webinar is not intended to be legal advice and may not be used as legal advice. Legal advice needs to be tailored to the circumstances of your issues. Every effort we have made here to make sure the information is current, but it is not intended to be an exhaustive explanation of the law in this area. You should seek the advice of your own counsel concerning any of your legal issues. And of course, you can contact the speakers with your questions. Great. So now, what I want to do is just to lead off here with some of the topics that we have, give you an overview of what we're looking at here. One of the first things we're going to look at are the background of the California statutes, the anti-deficiency statute, and also look at the one form of action rule. We're going to take a look at the exceptions that exist to the one form of action rule. We're going to discuss some cases that are now before the California Supreme Court that could really have an impact on all of these matters that we're discussing here today. And then we're going to end it with a discussion of actions against guarantors. So what I want to do is at this point hand it off to Mr. Tsai, who can take us into the one form of action rule. Eric?
Thank you, Don. All right, so under California's Code of Civil Procedures, Section 726, this is the provision regarding the one form of action rule. Now, 726 actually embodies two legal principles. First is the security first rule. And what that means is it's a prohibition against from secure creditors from ignoring the security and suing on the underlying note or debt. So in other words, you have to pursue the security first. And the second legal principle is the one form of action. That means that if there are multiple collaterals secured to a loan, the secure creditor is required to enforce all the security in a single action. And the failure to do so gives rise to an affirmative defense. And what that means is the affirmative defense could be waived. So it doesn't necessarily mean that the creditor will lose the ability or lose its lien on the collateral, but it could mean that you may not be able to foreclose on the collateral.
But Eric, let me jump in there. Doesn't when we talk about affirmative defenses, it means it has to also be asserted.
Yes. Now there are some exceptions to this rule. In certain cases, case law where the court has determined that the lender engaged in some sort of misconduct, it can actually be operate as a sanction. And we'll talk about this in a second and highlight in a case where it actually not only did the court determine that no, the lender cannot foreclose, but also prevented them from suing on a note also. So there's some little exceptions to these rules and little nuances, and we want to point this out right now is that we're going to go through the rules, but there are a lot of little nuances to these specific rules. So if you have any specific questions, we encourage you to email us, and we can address any of the issues.
Right.
So now, typically, what you're going to see the violations of the rule occur is where One, where the creditor sues on the note before foreclosing on the property. Two is where the creditor, starts a judicial foreclosure but doesn't include all the security. And sometimes, creditors may do that intentionally just so they can wait and see, possibly if the value of the collateral might go up. In San Francisco, that's, we all know that real property values are just skyrocketing here. So, these rules are designed to kind of prevent that. And then third is also to prevent secure creditors from exercising self-help remedies, for example, offsetting on a bank account or looking to other unpledged assets. And then we'll highlight some of these more specific examples in a moment here. Don, if you could take us to the next slide. All right, so the anti-deficiency rules are under Section 580 of the California Code of Civil Procedure. Now, there's a number of these we're going to touch on. The first one is 580B, and this applies to secure loans only. Now, second here, and so under 580B, it prohibits deficiency judgments following a foreclosure on a purchase money loan. This usually only applies to a 1 to 4 unit owner-occupied purchase money loans. It usually does not apply to refinances. It does not apply to guarantors, and it covers purchase money collateral mortgages, meaning personal property, if the loan is also a purchase money mortgage as to a 1 to 4 unit family owner occupied real estate. The next section under 580D, it's a prohibition against deficiency judgments following a non-judicial foreclosure on any loan secured by real property. So this applies to any real property collateral. So there's no limitation on the 1 to 4 unit, and it also does not require a purchase money loan. And then the next section is 580E, and this is a prohibition. It's a new provision following a short sale. And we're going to highlight this in some of the cases before the California Supreme Court. 580E only applies to 1 to 4 unit properties, regardless if they are owner occupied. The statute was first enacted in 2010 and only applied to first mortgages. In 2011, it was amended to apply to first and second mortgages. So the statute does not apply retroactively, and we're going to see some of the issues regarding short sale agreements that were entered into prior to Poker and McDonald, some of the cases we're going to talk to in a moment here.
Yeah, I was just going to throw in, Eric, that, with 580B, the fact that, the Coker case is in front of the California Supreme Court, really makes this a hot button issue, especially since they're using it to apply to short sales retroactively, sort of ignoring 580E at this point. So, I really think that's a big thing we're going to hit on today.
You're absolutely right. Thank you for pointing that out. And then just to remind everybody, the anti-deficiency rules apply to secure loans only. And even though it says it applies to secure loans only, we're going to see in a moment, some courts may disagree. So we're going to touch on that in a moment.
Hey Eric, it's Don. So, look, I'm not a California attorney, and that's why I'm relying on you guys to help me through this. So that 580B, purchase money loan application, does that also apply to commercial, or are we just talking about residential real property there?
Usually residential properties only. So 580B on a purchase money loan will usually only apply to 1 to 4 unit owner occupied purchase money loan.
Okay.
So for our commercial lenders on the attending with us here today, it's important to point that out too. So thank you, Don.
And so on the D, we're non-judicial on any loan secured by residential property. So if it's a residential property that has a commercial purpose, like a 1 to 4 family that the borrower is renting out, would it apply there as well?
580D would apply, right. So there's no restriction on the 1 to 4 unit owner-occupied restriction on the 580D. But now that only allows, it can only be done through a non-judicial foreclosure. And typically that's what you'll see is on most of these loans, because 580D is probably, it's the most broad out of these anti-deficiency rules. So
Sure.
essentially, on any loans that's non-judicially foreclosed, and most foreclosures in California are non-judicial, it means that the secured creditor is prohibited from seeking a deficiency judgment.
So where I'm going on this 580D, it could capture commercial loans.
Right.
Okay. Wow.
Right.
I'll also throw in there that it's the only of the 580s we're covering today that could apply to a guarantor as well. So I mean, it is definitely one of the bigger catch-all of the anti-deficiency rules in California. So
excellent. All right. We'll move
Okay.
ahead.
Before I'm going to go into Walker, I'm just going to give a quick background on the two types of foreclosures in California. So we've already discussed this a little bit, but the most common foreclosures here are non-judicial foreclosures. And for those of us that are familiar with this, you know that this is the much less expensive, quicker means of foreclosing on secured property, and there's no court oversight. There's no need for an appraisal or a judicial determination of the fair market value. Essentially, you follow the foreclosure statutes, and the sale goes to a trustee sale, and you're done with that. The borrower will have no post-sale right of redemption. The limitation to non-judicial foreclosure, as we just discussed, is that 580D will prohibit creditors from seeking a deficiency judgment. Now, even if that loan is not a purchase money loan. So on the other end is the judicial foreclosure. Now, this requires a lawsuit, and the plaintiff needs to show that the loan is in default and also prove the amount of default. This process will require you to get an attorney. You may have to engage in discovery, and it maybe even deal with an appeal. But this judicial foreclosures are the only means where you may be able to seek a deficiency in certain circumstances. All right, so we're going to jump into Walker, and this is a good background, kind of a primer on some of these rules. So Walker involved a loan that's secured by a mortgage on personal property and a deed of trust on real property. Now, after the default, the bank started a judicial foreclosure on the mortgage for the personal property. A buyer purchased the real property covered by the deed of trust. So when the bank tried to foreclose on the buyer filed a lawsuit arguing that the lender is barred from trying to foreclose under the one form of action rule. So as you may recall, we just talked about the one form of action rule requires the lender to enforce all the securities in one action. So the court held that the lender, because they went and foreclosed on the personal property first, they made an election of remedies and therefore waived its right to foreclose on the real property. All right, so Don, if we go to the next. So in Pack Valley Bank v. Schwanke, the debtors and their business partners signed a promissory note secured by property belonging to the business partner. The creditor released the property securing a note with the business partner's knowledge and consent, but then tried to sue on the note personally from the debtors. So in other words, the bank had a side deal with one of the debtors and essentially, agreed to release the security, and then they're going to pursue the debtors, personally. The court held that the action was barred because the one form of action rule required the creditor to proceed on the property, the security. And because of the creditor's misconduct, releasing the property without the knowledge and consent of the co-debtors, the creditor therefore actually waived the right on the note. So when we talked about earlier how even though it's 726 is an affirmative defense, it must be asserted. In certain circumstances, it can operate as a sanction, as we see here, where if the court determines that the creditor engaged in some sort of misconduct, it can impose a harsh penalty, and this is actually known as the Theiberia Rule. The next case
before you leave that, I mean, we do see that in other states sometimes. We call that, foreclose first or security first. So, again, my question is here, does this have application on commercial loans? Was this a commercial case? Was this a residential real property?
This was a residential property, but the rule itself it could apply to commercial property.
Wow. All right. Next case.
I just want to add in too, Eric, the fact that even if the defendant or borrower doesn't raise Section 726 as an affirmative defense, courts kind of treat it if the borrower, or not, excuse me, not the borrower, the lender doesn't bring it up, that they waive the security, the right to their interest in the security in general. I don't really know if we touched upon that yet, but I'm sure we will. So.
Right. All right. So we're on the case highlights the self-help situation. So Security Pacific, this case involved a loan secured by a deed of trust on the debtor's real property. Now, instead of foreclosing on the property, the creditor went and offset the debtor's deposit account in partial satisfaction of the debt. Now, the interesting with this one is what the creditor did before it sued, before it went ahead and pursued on the debt, it actually released the deed of trust and then sued, I'm sorry, not the debtors, but the guarantors to collect the remainders of the debt. Now, the court held that this did not violate the one form of action rule because the creditor had released the deed of trust and therefore waived its security interest, but they did not waive their right to sue on the debt. So the difference between this case and Schwenke is that here, the creditor's release of the deed of trust did not result in any prejudice to the debtor. The debtor was liable for the same amount regardless. Whereas in the creditor had a side deal with one of the debtors, and by releasing the deed of trust, it created a larger amount of debt that the debtors could potentially be responsible for. So, is there anything you wanted to add to this, Patrick?
I was going to ask if you could clarify a little bit what you mean by a side deal. I'm assuming it's sort of operated as a sanction here because it sounds like there's some foul play on the backside. But
absolutely right. So the general rule is, in order to release collateral under a loan, the creditor needs to obtain the consent of all the debtors. So if there are multiple debtors, they need a consent from all the debtors before they do this. But as we saw in Schwenke, if they have a side deal where they did this with knowledge of one of the debtors but not the other, that could operate as a situation where if there was sufficient misconduct and prejudice to the debtor, the court can apply the rule as a sanction and actually even prevent them from suing on the note itself. So in Dreyfuss, this is a situation where the loan was secured by separate deeds of trust on 3 parcels of land. And what the bank did here was the bank foreclosed non-judicially on one property and then went ahead and did this in serial foreclosures, one non-judicial foreclosure after another on the remaining properties. And of course, the debtor argued that this was a violation of one form of action rule because they did not proceed with one action, all the collateral. The court held that this did not violate the rule because the lender was allowed to proceed against multiple items of collateral as long as all the collaterals were pledged to secure one obligation. And also the Anti-Deficiency Rule did not limit the creditor's right to proceed on multiple items of collateral. And as you may recall earlier when we talked about the 726, the statutory provision, one form of action, and then the idea of the exception is that non-judicial foreclosure does not encompass court action. So the takeaway from this is if you have a loan secured by multiple pieces of land, you want to make sure that each parcel is secure by separate deeds of trust. And then that will allow you to avoid any 726 issues. But keep in mind, 580D, it restricts any deficiency judgments on any non-judicial foreclosures. So when you're structuring these types of deals, you got to keep this in mind. Multiple deeds of trust will allow you to operate in successive foreclosure, which is good, but remember that you will not be able to go ahead and seek a deficiency judgment. All right, so we'll go to the next case here. That's another example of the no court action exception. Kearns, this involved a loan secured by 2 liens. This is a mixed collateral. We have 1 lien on a car and a deed of trust on real estate. So the creditor foreclosed non-judicially on the debtor's car. The debtor then argued that, well, because of the foreclosure on the debtor on my car, the lender is not allowed to foreclose on my real property because the lender did not exhaust all the security in the original action. The court held that the non-judicial foreclosure was not a proceeding in court, so 726 did not apply. And also, the court held that the creditor could resort to additional security before engaging in other collection activity. And since the creditor did not seek a deficiency judgment in the non-judicial foreclosure, they rejected the argument that the creditor somehow, waived its right to foreclose under the deed of trust. So what we see here is that the non-judicial foreclosures are welcome, so to speak. It does not preclude you from attempting to non-judicially foreclose on other collateral under the loan.
Well, I have a question. Again, this is not a California attorney, very foreign to me, but was this motor vehicle, was it part of the same loan that was secured by?
Exactly.
Okay.
So the loan was secured by two liens. So
right. Okay. So because there was a personal property element of the loan security that implicated the potential, at least, for the anti-deficiency statute, and the one. And I'm sorry for we're talking about no court action. Sorry, correct?
Right.
Okay.
They kind of roll together a lot of times because at least an argument can be made where if the loan was secured by real property, even if there's other collateral, in this case a mixed collateral situation, as long as there's a real property element, exactly like you just pointed out, it implicates 726.
I see. Thanks.
Yeah. All right. So on the next example, we're going to look at what's called the sold out junior example. This one's kind of interesting. So in the first case, National Enterprise, this involved a bank that made successive loans to one borrower. So all these loans are secured by successive deeds of trust. So it's multiple loans secured by multiple deeds of trust on the same property for the same borrower. The bank failed and the borrower defaulted. The receiver sold two of the loans to different parties. The senior lien holder went ahead and foreclosed, filed a judicial foreclosure to foreclose on the senior lien. And then the court held that 726 did not bar the junior lien holder from bringing an action to recover on a debt after the security was lost in foreclosure. And this was because the junior lien holder's interest was a bona fide separate debt secured by the same property. There's no security left, so the junior lien holder had no other options but to recover the distinct debt. So it's kind of a carve out for the sold out junior lien holder, so they can still have an opportunity to collect on its debt.
And Eric, do you mean that the junior lien holder can proceed directly against a borrower personally?
You are absolutely correct. Yes. So because of the security interest, it's foreclosed. The junior lien holder's security interest foreclosed. So it no longer had a lien, so it wouldn't be able to foreclose on the property anyways. So the only option they would have at this point would be to go after them personally, sue on the note.
Okay. And always keep in mind with this kind of stuff that it's still subject to the anti-deficiency rules we talked about earlier as well. So.
Right. So on the next case, we're going to look at the how this exception will not apply. So in Bank of America v. Mitchell, this involved a similar situation as we just talked about. This is actually a purchase money loan secured by two notes, so a first and a second on the same property. After default, the lender foreclosed on the senior, sold the property, and then this is what the lender did. The lender went ahead and sold and assigned a junior loan. And the court held that the assignee would not be able to pursue on the debt because 580D would not have allowed the original lender to do so. So even though there's an exception where the junior lien holder can go after the loan after a senior's foreclosure, this exception doesn't apply where the junior lien holder had also held the senior lien. So you notice that the small nuance there. Essentially, what the takeaway from this case is that you can't sidestep these rules. So the lender, if they foreclose and then lost the interest, the lender never would have been able to pursue the debtor for anti-deficiency anyways. You can't go ahead and try to sell this to, a third party, a straw buyer, things like that, in an effort to try to collect from the debtor. The courts are just not going to allow that.
Hey,
Yeah, I
Eric,
was they were playing games and got caught. So
so yeah,
Exactly.
this I'm going back to Woods for a second. This is very interesting to me. So in Woods, I understood at least. I thought there was one lender who held both the senior and the junior at one time. Correct.
Right.
And in the next case, which is Mitchell, you had the same circumstance. You had a lender who held both loans, right?
Right. Right.
So is the critical difference between Mitchell and Woods when the point of time in the life of the loans that the original lender sold one of them? I mean, what's the
Exactly.
okay? So it was it
Exactly.
sold after default?
Right. So in Mitchell, they sold after the junior had already been extinguished.
Yes.
So
Okay.
they were trying to get around the anti-deficiency rule
I see.
by reselling the debt. Right.
Wow.
Yeah. Yeah. So we have a couple other exceptions here. So on the next case, Cruz, and here's what happened in this case is actually really interesting. What the creditor did was they foreclosed judicially and obtained a judgment. So they went through the whole process and got a judgment, but the property hadn't gone to sale just yet. It then sought to modify the judgment, so at court, to allow them to go ahead and go to a trustee sale instead. The court held that this would be unfair because this process, i.e. allowing a creditor to go through this whole judicial process and then allowing to foreclose non-judicially, would allow the creditor to preserve the right to a deficiency judgment and then wait to see if the property value increased during the judicial foreclosure process and then change over to a non-judicial foreclosure just to extinguish the debtor's right of redemption. So the courts are just not going to allow you to do things like this. Now, you do see it is common for creditors to file a judicial and non-judicial or pursue a judicial and non-judicial foreclosure at the same time because a judicial foreclosure will allow the creditor to preserve the property and collect rents, via a receiver, while it's possibly exploring a private sale. I would think this is a little less applicable in a residential situation, but in commercial properties, this is a much more common. So the bottom line, the rule in this case is that election of remedies is final when you complete the sale or obtain a judgment of foreclosure. So you can run a judicial and non-judicial foreclosure concurrently, but once you obtain your judgment of foreclosure, you're done. You're not going to be able to go back and try to get a non-judicial foreclosure. And then the next example, Nungary, this is the court. This involved a debtor where they negotiated a loan modification. The debtor tried to argue that the lender collected these loan mod trial plan payments and applied them to the unpaid principal balance of the loan. That process was an election of remedy, and therefore the lender is precluded from trying to foreclose. The court held that no, the one form of action does not apply here because the debtor voluntarily made these monthly payments hoping for a loan mod. The offset of payments was not an election of remedies subject to the one form of action rule. So, all right, so with that background in mind, we're going to get into some exciting cases here that are before the California Supreme Court. And Don, if we go to the next slide, the first of these is Coker v. JP Morgan Chase Bank. Now, this case involved a short sale for a purchase money mortgage loan. The borrower asked the lender for a short sale, and the lender said, look, we can only do this, we'll agree to do this and release our lien if you agree to remain responsible for any deficiency. Now, this is a very common fact pattern, especially during the time when this case was originally in the courts. After the trustee sale, the lender pursued the borrower for a deficiency, and that's defined as the outstanding balance on the loan and the money received by the lender after the sale to a third party. So they're looking to go after the borrower for the deficiency, and then the borrower files suit that, look, I'm protected by 580B. The lender is not allowed to come after me for any deficiency judgment, even though I had agreed to do this, to this short sale process. The court ultimately held that the anti-deficiency protections apply to any loans used for purchase of residential real property. or purchase any real property. It doesn't require a foreclosure. And then deficiency judgment is prohibited as long as it was a purchase money loan on the original property, regardless of sale. So, in simple terms, the court applied 580B even though there was no foreclosure here. And the court said that the borrower is not required to enforce the one form of action rule in order to get 580B protection. Why is this case important? If we go to the next slide, Don. This case is important because, to clarify an earlier point, I think we might have misstated something earlier, but the anti-deficiency rules only apply to secure loans only, right? So if you think about how this process works, if you're familiar with short sale process, in order for the short sale to go through, the very first step the lender needs to do, aside from obviously getting the agreement from the debtor, is it needs to release the deed of trust on the property before it does this. So once the deed of trust is released, the loan itself is no longer secured. It becomes unsecured. So by definition, 580B should not apply. But Coker held exactly opposite of that. And that's what's really interesting about this case. It's saying, no, 580B protects the borrower from a deficiency, even though there was no security and even though there's no foreclosure here. And this is why it's such an interesting case here. And I know Patrick has some things to add to this as well.
I was going to say the same thing applies to the security first part rule of the one action rule. I mean, you're taking a loan that's secure and making it unsecure, but then they're saying that Section 726 still applies because of the security first rule, even though it's not secure anymore. So it's kind of backwards, in my opinion. I don't really understand what they're trying to do here. I think part of it was, maybe there was some other things going on with the court, because I know that they were looking at 580E, which wasn't in effect yet, but you can kind of tell that's what they're trying to get at, is trying to apply 580B to 580B and get the same result, even though I don't think that's correct. But
I completely agree with you. I think the decision is inconsistent with the plain language of the statute, and there is some borrower-friendly undertones to the case itself, and they were, in my opinion, also is that they were trying to expand the 580E protections to people who had gone into short sales before the enactment of 580E. And another thing I wanted to point out is, the short sales are not like foreclosure. They're very, very different, and the main difference is that it's not forced. The borrower an option. The borrower does not have to ask for a short sale. The borrower can always demand the lender, like, look, I need you to foreclose on my property because I don't want to get a deficiency judgment. So they can always force the lender to foreclose, and there's no way for the lender to force the borrower into a short sale. It can't be done unilaterally.
Well, I was going to throw in, Eric, to both you guys, as I look at this from my time in the past, mostly in commercial, dealing with these types of issues, I mean, these are negotiated between borrowers and lenders, and there's an understanding as to what can be paid from the sale, where it's going to go, what it's going to be applied to, what the mortgage lender is going to take a bath on. And I'm wondering, I'll throw this out to you, because I'm, again, looking at this in the commercial context, because you say it could apply, is if I were a lender, I would say, look, I just don't want your signing off on this saying you're going to remain liable. What if I made a new loan for the balance? What if I just said, look, you know what, you're going to pay off that existing loan with a new loan, and we'll give you a year or 2 years to pay the deficiency. I mean, I'm just throwing that out there, but maybe the court wouldn't like it. Maybe, as you pointed out in another case, they'd say that's an end run. But, if applying the logic here, that would seem to me be a way to avoid this type of result.
That's absolutely right, actually. I think that's a great tip, and that's something that's definitely creditors should look into, a secure creditor as an alternative to this.
I'm not saying it'll work, Eric. Remember, we're not giving legal advice, but it would just seem to me that if they're going to treat the loan as having become, lost its security, as I see it, is that the security's been exhausted, so you're done. Maybe that's another way to look at it. It have to be explored further. And we have to see what the California Supreme Court says here ultimately as well, though. But this is very harsh. And I think that, many of us in the industry realize that short sales have benefits to borrowers and lenders. That short sale may be the best opportunity to sell that house at the highest price or that property at the highest price. And with this type of decision, I could see lenders being very wary now of agreeing to short sales where they're going to have a sizable deficiency and they're going to have this applied to them. I think this also avoids or creates the problem we're trying to avoid, that is empty homes. So policy-wise, I think this is a horrible decision.
Well, the other issue is they're applying 580B retroactively. So there's a possibility that any short sale and deficiency that a lender received prior to 850E becoming, 580E becoming effective can be voided with this appeal court's decision. And I think that's why Chase is really fighting this hard.
Sure.
Because, at the moment going forward, 580E is already establishing anti-deficiency protections for short sales in California for, 1 to 4 unit properties, regardless if they're owner occupied or not. So.
Wow.
Right. And I believe one of the briefs they submitted to the Supreme Court mentioned that they estimated the short sale agreements that could potentially be affected somewhere around 200,000. So there was a lot of short sales done during this period of time, and these loans that would be affected. So it's interesting to see what this will happen. We have another interesting case here, and it's runs along the similar situation. And Patrick's gonna take the lead.
Well, I was going to add to Coker before we move on that the fact that they also held that you can't waive the anti-deficiency rules by contract, which is another big thing, because a lot of these short sale agreements, as you guys know, have a thing in there that says if we do the short sale that the borrower still remains liable for whatever the deficiency is going forward.
Yeah.
And Chase tried to argue that, and the court said that you can't do that either, that it's an anti-deficiency protection, you can't contract around it as well. And
I think that, Patrick, and that's what why I was a little bit hesitant even on suggesting even that making a new loan may not even work, because it could be deemed as really an end run on this protection that the statute offers. It's essentially looking to create a waiver by making a new loan, and I could see an argument being put forward that's prohibited.
Yeah, these statutes are pretty killer with the anti-deficiency, especially in how Coker's looking at it. I'll say it now, this court is pretty consumer friendly, to say the least.
Sure.
And that's come out of my own district, so. But.
All right, so the next one, First California Bank v. McDonald. This case involved a husband and wife that obtained a loan secured by 2 parcels of land. The loan went into default after the husband died, and the bank and wife agreed to a private sale of one of the parcels that was their separate property. So I'm going to stop for a second and point this out. So this is a single loan with 2 parcels of land, and with the one parcel was owned by the wife separately. So it was her own separate property, it was not community property. And when the bank and wife agreed to the private sale of one of her separate property, it was done without the consent of the husband's estate. And this is another important point, is in a lot of most situations when husband and wife situation, and the husband dies, you generally see the wife is generally appointed as the representative of the estate, but in this case it wasn't. So just kind of highlight that as the background here. There's i.e. dispute over the rights to the estate here. So the bank then filed a judicial foreclosure on the remaining parcel and sought to obtain a deficiency judgment against the estate. The representative of the husband's estate argued that the bank waived its right to deficiency judgment when it sidestepped the requirements of 726 by agreeing with only one of the debtors, the wife, on the sale of her separate property and releasing a deed of trust without the knowledge and consent of the co-debtors. The court held that the bank was required to include both parcels of real property in the judicial foreclosure action unless the bank can show that the debtors, all of the debtors, had consented to the release of the second parcel. And then the bank's failure to consent waived its right to seek a deficiency as a result of this. Patrick, I know you want a couple things to add to this here.
Well, the first thing is the court, and it wasn't a holding necessarily, but it did discuss that a debtor can waive Section 726 in the anti-deficiency statutes by contract, which directly contradicts what they were saying in Koch or what we were talking about earlier. So exactly. I mean, I find that really interesting. It's probably the fact that why they're both going to the Supreme Court, because one of them's gonna have to be wrong and one of them's gonna be right. So exactly.
And another interesting point is that the briefing has been held, just put on hold in McDonald because the court's going to wait until a decision's made on the Coker case. Also, another thing to point out too on McDonald, this was a summary judgment case. So the case was actually remanded so that the trial court can determine if the bank can still pursue on the remaining parcel, and it might be able to still get a deficiency if it can show that the estate consented to release of the second parcel. Because again, remember, the anti-deficiency rule provisions apply only to a secured collateral, but the debtors can always waive their right to the one form of action rule. So.
And Eric, just a quick question: if they do waive the right to the security, what would be their recourse going forward then? The lender in this case.
They can sue it on a note in most situations. You want to make sure it depends on how the loan is structured. So if it's one loan and there was multiple collateral, and then the first action was a judicial foreclosure, then they were required to include everything in that first foreclosure. So then they wouldn't be able to pursue on the second collateral because that's seen as a pursuing for a deficiency judgment, so to speak, if that makes sense there. But if they had done a non-judicial foreclosure, that would be okay because that does not involve a court action. So 726 is not involved. The loan, as long as the lien is on that second, the lender could go into a non-judicial foreclosure on the second piece of property there. I hope, did that address your point there, Patrick?
Yeah, I was just, I want to make sure that point's across that it's not, if they do waive the security interest to go after it, there's still some sort of recourse left for the lender. Right. Granted, it's not very good in these situations usually, but there's still something. Right.
So one of the things we wanted to kind of touch on too is, when there's a violation of 726, what alternate remedies should be available, short of the servicer losing its right to pursue deficiency judgment? We don't have an answer to this, but we're thinking, the court should be able to carve out some sort of remedy for the servicer in these situations where the servicer acted in good faith, i.e., in this situation, the servicer. So in McDonald, like I talked about earlier, it's possible that when the bank did agree to the short sale of the private sale, it might have done so under the presumption that the wife was the authorized representative of the estate, or at least had the consent of the estate. That's a possible consideration where the servicer acted in good faith and there was no prejudice to the borrower. So in this case, another important thing we almost left out is when the lender agreed to the private sale in this case, it didn't give the proceeds just to the wife, even though it was her separate property. It applied the sale, the proceeds to the loan, therefore reducing the amount of deficiency that could be pursued against the estate. So the representative estates were complaining about this, but they weren't prejudiced in any real, practical way. So we do think that there should be some sort of rule or exception carved out here to help servicers when they act in good faith and there's no prejudice.
And I'll just add into that the concurrent opinion really touched upon that and how harsh the result was here, especially due to the fact if if the lender was aware of the trustees being the co-debtors in this case, it could have just approached the co-debtors and asked them if they would consent to the short sale, and if they said no, they could just judicially foreclose on both pieces of property to get the same result.
Exactly.
So, like you were saying, there was no bad faith on the lender's part. They were just kind of stuck there. There's nothing they could do about it. So I think there could be an exception, but.
Right, and then you can kind of read between the lines. The private sale most likely brought in a larger amount value for the property than if they had gone and sold it through auction. So in this situation, it just seems like it's such a bad result, and it just discourages lenders from exploring alternatives to foreclosure, and a lot of times with borrowers, and something needs to be done. So.
Yeah, I believe, if I remember correctly, the lender didn't even know that the husband was dead.
I can't remember exactly, but right, it's something along those lines. So.
And they didn't know about the trust being involved with it until it was too late, basically.
Yeah. All right, Patrick, I think you want to take us through the issues with guarantors.
Sure. Before we move forward, I just want to point out that when looking at guarantors and whether they have any sort of anti-deficiency protection, the question you have to ask yourself is whether an action taken by the lender has destroyed the guarantor's possibility of seeking reimbursement from the. If the guarantor can still seek some sort of action or file some sort of action against the debtor to satisfy the deficiency judgment, there will be no anti-deficiency protection for a guarantor. Just keep that in mind going forward. Don, we can go to the next slide. The Union Bank versus Gradinsky matter was one of the first cases to really look at whether a guarantor was afforded anti-deficiency protection under the Section 580 series. And what you'll learn from here is the typical fact pattern where a lender non-judicially foreclosed on a debtor and then subsequently sought a deficiency judgment against the guarantor. And what the Union Bank Court had to look at was whether a guarantor is entitled to 580D anti-deficiency protection when a lender non-judicially forecloses on a debtor. And what the court held is that when a lender elects to non-judicially foreclose, it destroys the security and also destroys the guarantor's possibility of recovering reimbursement from the debtor. And what this means is a lender is stopped from pursuing a deficiency judgment against the guarantor. And what the court's reasoning here was the fact that they were just trying to make sure that a lender couldn't get around the anti-deficiency statutes by non-judicially foreclosing upon a debtor and then simply seeking the anti-deficiency or the deficiency amount against the guarantor. And that's why they held that the lender was stopped from seeking such a deficiency judgment against a guarantor in this situation. And going forward, this will be known as a Gradinsky defense and is usually discussed in most cases dealing with guarantors and the anti-deficiency statutes. John, we can move to the next slide. In this case, this is Consolidate Capital Income Trust, another California appellate decision. And what happened here was there was a loan extended to a debtor corporation that was secured by a guarantee. The guarantor in this situation was the sole owner of the debtor corporation. After receiving the loan, the guarantor sold the debtor corporation to a buyer. And in exchange for selling the corporation, the guarantor agreed with the buyer to waive all rights and claims the guarantor may have against the debtor corporation. Subsequently to selling the corporation, the buyer defaults on the loan and the lender non-judicially forecloses on the security in this matter. And what happened here is after doing so, the lender signed a deficiency judgment against the guarantor, and in exchange, the guarantor claimed that he was protected by the anti-deficiency statute. So what the court had to decide here was whether a lender was stopped from obtaining a deficiency judgment after pursuing a non-judicial foreclosure. And what makes this case unique is the fact of the waiver agreement signed between the guarantor and buyer concerning any claims and rights the guarantor may have against debtor corporation. So the main question the court had to consider was whether the guarantor, or excuse me, whether the waiver of rights released any rights the guarantor could have against the debtor because of the fact that due to the fact that the waiver agreement was signed and executed prior to the lender foreclosing on the property. And what the court decided was this waiver agreement between the buyer and guarantor was ambiguous and too general to determine if it affected the guarantor's rights of subrogation flowing from the acts of a third party, which in this case was the lender. It should be noted this was a summary judgment motion, and it was remanded back to the trial court, stating that the issue of fact concerning whether the guarantor had waived its subrogation rights against the debtor. Despite the fact that there was no real decision reached here concerning whether the guarantor effectively waived anti-deficiency protection, it should be noted that you should look out for any sort of agreement that's not directly affecting the loan documents or a guarantee may somehow affect them going forward and cause a waiver of some sort of anti-deficiency protection. Thanks, Don. We can move to the next slide. Oh, perfect. The next area that we're going to cover is waiver by guarantors. And just at the onset, it should be noted that a guarantor has the ability to waive their subrogation rights and any defenses and or claims it may have under sections 580A, B, D, as well as section 726, which is the one action rule, which we discussed earlier. Don, we can go to the next slide. This is an opinion concerning whether a guarantor can waive his anti-deficiency rights. In Cathy Bank versus Lee, it was another typical pattern in that the lender foreclosed on a property non-judicially and then sought a deficiency judgment against the guarantor. What makes this case unique is the fact the guarantee agreement contained a provision that stated the guarantor shall be liable to lender for any deficiency, even though any rights the guarantor may have could be destroyed by actions taken by the lender. And what the court had to consider here was whether this waiver provision explicitly waived a guarantor's anti-deficiency protection. And what the court ended up holding here was that said waiver was too general and broad to actually waive a guarantor's anti-deficiency protection. The court went on to farther state that in order for a guarantor to waive its anti-deficiency protections, the waiver must state that the destruction of subrogation rights creates a defense to a deficiency judgment, and that the guarantor is knowingly waiving this specific defense. Now, I believe this was a really, really explicit opinion, as I thought the waiver agreement in here was sufficiently stated, as the language was clearly referring to the Grudzinski defense. So, what happened was, if you move to the next slide, is the legislature appears to agree with me as they subsequently passed Civil Code Section 2856 in response to the Cathy Bank decision. And what 2856 states is that a guarantor of a note secured by real property may waive any anti-deficiency protections. And the most important part of Section 2856 is the fact that it contained model waiver language that could be found to adequately waive the anti-deficiency protections a guarantor may have. And the next case we're going to talk about is going to illustrate that point. In Gramercy Investment Trust, another California appellate decision, and this case involved a large commercial loan, I believe is about $35 million, which was supported by a guarantee. The guarantee included a provision, a waiver provision, that waived rights under sections 580A and 726B, which is again the anti-deficiency law and the one action rule. What happened here was what always happens. The the debtor defaulted on the loan, leading the lender to non-judicially foreclose upon the property and then seek a deficiency judgment against the guarantor. Due to the size of this loan, I believe the deficiency judgment sought was about $30 million. What the court had ended up analyzing in this case was whether the waiver provision contained in the guarantee was sufficient to waive a guarantor's anti-deficiency protections. And what the court ended up holding that the guarantor did waive its anti-deficiency protections because the waiver was clear, unequivocal, and in language expressing the intention to waive said anti-deficiency protections. The most important part of this case is the fact that the court approved Section 2856's model language concerning waiver. So this, despite the fact that the guarantor still challenged the waiver, it is good to know that there are a lot of opinions out there that support using the 2856 model waiver language. Okay, Don, we can move to the next slide. The final area that we'll cover today is actions against guarantors and sham guarantees. And what a sham guarantee is a guarantee that is executed by a party who is already obligated under the guaranteed obligation, meaning that the guarantor does not incur any additional liability by signing the guarantee. And the most important thing to take away from this is when there's a sham guarantee is found, the guarantor is still afforded anti-deficiency and one-action protection. This is because the courts consider the guarantor to actually be the debtor. So, sham guarantees are pretty important in that facet. Don, we can move to the next slide. The first case that's going to show you what a sham guarantee looks like and the implications it may have is a Ninth Circuit adversarial proceeding bankruptcy matter. And in the way of the background, we're going to have to look at the corporate formation of the debtor partnership here. The debtor partnership was a limited liability partnership formed in California, with its general partner being a partnership formed in Arizona. A quick way of background facts in this matter: the debtor partnership purchased a car wash from the creditor, which was with a $1.5 million carryback loan. The carryback loan was evidenced by a promissory note and secured by the car wash as well as the equipment located on the car wash. Most importantly, this promissory note was signed by the debtor partnership's general members, meaning the Arizona partnership members actually executed the promissory note agreement here. Also, the promissory note contained a guarantee provision signed by one of the individual partners so that he could be personally liable for any deficiency on the loan. Subsequently, the promissory note was split into two different notes, one of which, I believe it was the third note, that was secured by the car wash and still contained the original guarantee provision holding the general individual partner personally liable for a deficiency judgment. What happened next was the usual situation where the debtor defaulted on the loan, but in this case the lender sought an action on the guarantee against the individual guarantor and attempted to levy the guarantor's bank accounts. In response to the lender's action, the individual guarantor raised an affirmative defense under 726, which is the one-action rule. And the reason he raised this was he claimed the creditor could not only sue upon the third note and had to bring all the collateral and security that was secured by the other notes under the one-action rule. So what the court had to consider here was whether the individual guarantor was also a primary obligor under the promissory note, such that the purported guarantee here did not add any additional liability, meaning that if the creditor proceeded against the guarantor member, it had taken one action pursuant to Section 726. And this is going to go back to why we had to discuss the formation and the corporations and partnerships in this matter. As we previously discussed, the General Arizona Partnership was personally liable for the California Limited Partnership debts. So what the court had to do in this situation was determine if this individual guarantor was still jointly liable for any of the partnership assets and debts. And what the court decided was, because the individual guarantor was a general partner of the partnership, he is jointly liable for any partnership debts, meaning the creditor's action against the member was constituted one action under 726. And as a result, this is where the issue really came in, was the fact that the court considered this under a one action rule. And because the creditor levied the guarantor's bank account against the security, the court determined that the creditor waived its right, waived its security interest in this matter, and it could only go after the guarantor personally. So this kind of illustrates what happens when there's a sham guarantor, because if the court finds that, it begins to unravel, because the anti-deficiency statutes kick in, as well as the one action rule. So this is definitely something you need to watch out for when having a guarantor guaranteeing a loan. You should ensure that it's just not a partner of just a partnership or a small closed corporation with a single member, and that single member is executing the guarantee. Because when this happens, it's going to trigger the anti-deficiency statutes, as well as the one action rule and the protection that are given underneath each one of them. Don, we can move to the last slide. The final case that we're going to cover today is Talbot versus Hutswith. This is a 2008 case where a lender extended a loan to an investment trust. The loan was secured by a guarantee signed by the settlers of this investment trust that the loan was extended to. The investment trust subsequently defaulted on the loan, and the trustee foreclosed and then sought a deficiency judgment against the guarantors in this matter. Guarantors contended that they were afforded anti-deficiency protection, and that Section 580A applied to them. What the court had to look at here was whether the guarantors were afforded any sort of anti-deficiency protection, and whether the guarantors of the loan were true guarantors. The first question the court looked at was, did the guarantors take on any additional liability in this situation? The issue here was the fact that the guarantors were the settlers of the trust of the loan that they were guaranteeing. The court decided that because the guarantors were secondary beneficiaries of the investment trust, and the fact that the guarantors use an LLC as the trustee, their personal liability was extremely limited for trust obligations. Thus, the court determined that the guarantors were true guarantors in this situation, and were not entitled to 580 protection. So what essentially was found here was the guarantors in this situation were sufficiently removed from any obligation on the primary obligation here, meaning they were not entitled to any sort of anti-deficiency protection, and this was not a sham guarantee. Again, with these sort of cases, I think everyone needs to watch out for who is actually signing the guarantees in these situations, to ensure that a sham guarantee situation does not occur. Because as we discussed before, there's a lot of things that can go sideways if that happens and an action is filed.
Well, wow, Patrick, that was great, and I really appreciate what I think was quite a run-through on the issues facing guarantors. And, I hope that we have a few questions here, and Eric and Patrick, could you stay a few more minutes and help us answer a couple of these? So, the first question I have here is, can we obtain a deficiency judgment on a short sale for an investment or commercial property. Which one of you guys want to take that?
Issues facing guarantors.
I'm hearing a reverb, guys. I think you may have your.
Question here, and
I can take that one, Don. Can you hear me?
Yeah.
Okay, great. Well, short sales now are governed under Section 580E now. So we went through a discussion with Coker and McDonald, which kind of was trying to expand the 580B. But for new short sales, just to make the rules simple for everyone here, the short sale rules that prohibits anti-deficiency judgments applies only to 1 to 4 unit properties. So that typically would not include any commercial properties. But there is no restriction for owner-occupied properties. So the deficiency, you would not be able to get a deficiency if there is a 1 to 4 unit property and whether or not they are owner-occupied.
Excellent. Thank you, Eric. And Patrick, I think this, you're going to have to help me through this question. I think you saw it come through on the email. What is a good way to try and ensure that a guarantor is not primarily obligated under the original security? Am I reading that question right, Patrick? Oh, looks like we dropped Patrick. No, he's coming back in. So let me skip that question, and we'll have Patrick answer that in a second. Eric, I have another question for you. What can we do if we started a judicial foreclosure and realized we did not include all the collateral? And that happens, I think, more often than not, especially when we're dealing with commercial loans. What can we do, Eric?
Absolutely. There's a few different things you can do, and of course, this question goes to the one form of action and security first principles, and under the one form of action rule. So as you recall from the presentation, under 726, secured creditors are required to go after all the security at one time and in one action. So if you started a judicial foreclosure and subsequently realized you forgot to include all the security, the first thing you can do is, if it's possible, go ahead and dismiss the lawsuit and refile. Or another option, of course, is to amend the complaint and include the omitted security, assuming that the security is still subject to the lien. If for some reason the security is no longer, the omitted security, the lien's no longer on the omitted security, then it becomes kind of a problem, because in your inability to comply with the security first rule, it would not, it's not an absolute bar to prevent you from seeking a deficiency judgment, but you would have to basically show that all the debtors had waived the one form of action or security first rule, basically the protections under 726. So if you recall, one of the cases earlier we had talked about, and also under McDonald, is that you can obtain consent from all the debtors, and if you could show that you had obtained consent from all the debtors, you would not have violated 726, and therefore will be able to continue and potentially get a deficiency judgment. And of course, the last option you can always do is basically waive your right to 726 and essentially just waive your right to any deficiency judgment. So as you recall, the general principle with all this, the anti-deficiency rules apply to secured interests only. So if you were to essentially waive your right to, collect under the security, you're not waiving your right to the debt. You still would have the opportunity to sue under the debt itself. So I hope that answered that question.
I think so. Very good. And Patrick,
yes, I should be back now. Sorry about that. I had some technical issues.
That's okay. Hey, look, after your run through on the guarantors, it's good to come up for some air and get a drink of water. I understand. So we have a question. I think this is right in your area. What is a good way to ensure that someone signing as a guarantor is not primarily obligated under the original security?
You know, especially in a commercial loan situation, I would ask the guarantor to provide any sort of corporate formation documents he has. For example, articles of incorporation, to see if you can find out if the guarantor is listed in the articles or any of the corporate documents in any form, to see if he would have liability under the primary obligation, which is probably what they should have done in the NRA Prestige Limited Partnership matter.
Yeah. I think that's a great idea. You know, again, back in the day when I did commercial loan documentation, we would ask for all the organizational documents of both the borrower and any corporate guarantors, and obviously review them for those types of occurrences. And I think that today maybe we've gone away from that a bit, but as that case evidenced, it went away. But I think it's very important. I think it was great that you highlight that you look at the organizational documents and understand that in some instances, persons within an organization can be liable directly on a loan, even though they are a guarantor. Well, great, guys. I really appreciate everyone standing by, and we have this recorded. We'll have it back to you soon. Eric and Patrick, thank you very much.
Yeah, thanks for having us, Don.
Thank you.
Great. And we'll see you all in the next webinar. Have a great day.
All right, thanks a lot.